Absolutely. And what would you say is like the ideal time for the appellate group to get involved in a trial that you anticipate maybe there being some appellate issues?
99% of the time, it's sooner than when my phone rings.
I had a feeling that was going to be your answer.
I tend to get calls because this is the nature of life. The people that call me, clients, more usually insurers and insurance companies, they have a lot of things on their plate, and they don't necessarily have the luxury of thinking, 6 months or a year down the road. But the sooner, the better, because there are things you can do early in a case that might be to your advantage from an appellate perspective that you can't do later on. For example, I sometimes get brought in when it's too late to move for summary judgment without permission of the court, even though there might be a dispositive legal issue. Or I get brought in after the pleadings are closed, and in hindsight, you wish that you'd raised a special defense or something like that. Most of the time, if we are brought in before the case actually goes to trial, it's not too late, because the most important things happen at trial. Press to charge the jury, if it's a jury case, the right kind of trial briefs, making a record of objections. I think one of the ways in which we help the most is reminding trial lawyers of the importance of explaining why a ruling hurt their case. Trial lawyers are very good, most of them, especially the ones here, at explaining why a judge is wrong or making an objection. But that's only half the equation when you get to the appellate court or the Supreme Court. They want to know, well, if the judge was wrong, was it harmful? How did it prejudice your client's case? That's where our advice a lot of the time helps. Make a specific detailed record. If you hadn't excluded our expert judge, here's what the jury would have heard. Then a bullet point list of ways in which it hurt your case.
Yeah, it's really a dual function. As the trial attorney's trying to persuade the jury of the facts of the case, you're trying to preserve some of the legal issues that maybe not be missed but overlooked by the trial attorney that's in the weeds of the facts of the case.
Absolutely, Nico. And I think that ties into something I mentioned earlier, that our involvement in the case frees up a trial lawyer to do what they're best at, which is persuading a jury. Absolutely. So that maybe I'm unnecessary, or at least we're defending a win on appeal rather than trying to get the judgment overturned. But there are many things that a trial lawyer, who's out a lot of cases, maybe he has lucky enough to have an associate to do this, but still taking depositions during off days from the trial, preparing his next witness, getting evidence together, getting a little sleep if he's lucky enough to get to do that during a trial. But in the meantime, I or Logan or Laura or Mike can be drafting jury instructions or drafting a motion in limine or preparing a motion for a directed verdict or whatever issues might come up. That's where we add value.
Great. Well, Dan, thanks a lot. I really appreciate you taking the time with me. For those of you watching at home, again, this is Dan Krisch, the chair of the Halloran and Sage Appellate Practice Group. Dan, thanks a lot.
My pleasure, Nico. Talk to you.
Good talking to you.